It wasn't the fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
Amidst heated debate, Congress confronts the Supreme Court over gun control. Recent decisions have ignited a legal firestorm, challenging established norms and reshaping the landscape of firearm legislation. Explore the implications. Supreme Court's game-changing ruling. The New York State Rifle and Pistol Association Inc. versus Bruin decision, handed down by the Supreme Court, represents a pivotal moment in the landscape of gun rights in the U.S. This 6-3 decision, authored by Justice Clarence Thomas, not only addressed a specific New York gun permitting system, but also provided new guidelines for evaluating the constitutionality of gun laws more broadly. Its significance cannot be overstated, especially considering it marked the first major Supreme Court decision on gun rights in over a decade. Justice Thomas's previous concerns about the Second Amendment being treated as a disfavored right set the backdrop for this ruling. Federal judges have swiftly cited the Bruin decision in a range of cases, from overturning assault weapons bans to addressing restrictions on homemade firearms and the carrying of handguns by older teenagers. These include challenges to zoning restrictions on shooting ranges, licensing and training laws, and even the federal ban on certain misdemeanor offenders from possessing firearms. The ruling effectively redefines the legal framework within which these issues will be adjudicated. One of the most significant shifts brought about by the Bruin decision lies in the framework it establishes for addressing Second Amendment challenges. Andrew Willinger, the executive director of Duke Center for Firearms Law, rightly points out that this development has sweeping implications for future legal battles over gun rights. The ruling introduces a fundamentally altered approach to evaluating the constitutionality of gun laws.
Certain bump stock devices, like the one used in Las Vegas, are illegal under current law.
Under the new rule, these firearm owners will be required to obtain special registration, surrender or destroy their brace.
One that emphasizes historical context and precedent. This nuanced aspect of the Bruin decision acknowledges that legal interpretation, even within the bounds of historical analysis, requires careful consideration and thoughtful judgment. Furthermore, the ruling sparks discussions about the historical touchpoints for assessing a restriction's constitutionality. Should the benchmark be the 1791 enshrining of the Bill of Rights or the 1868 ratification of the 14th Amendment, which extended protections against federal infringements on gun rights to state and local governments? This debate underscores the evolving nature of legal interpretation and the necessity for ongoing dialogue in the legal community. In supposition, the New York State Rifle and Pistol Association Inc. versus Bruin decision represents a watershed moment in the realm of gun rights. Its influence extends far beyond the specific case at hand, shaping the future of Second Amendment challenges. As the legal community grapples with the implications, it is clear that the Bruin decision will leave a lasting mark on the discourse surrounding gun rights in the U.S. Bruin ruling reshapes gun laws. The Supreme Court's recent decision in the case challenging New York's system for approving licenses to carry firearms in public has had far-reaching implications. The ruling, passed by a 6-3 majority, declared that the state's rules, which granted government officials discretionary power in issuing licenses, violated the Second Amendment. What elevated the significance of this ruling was Justice Clarence Thomas's commentary on how courts should evaluate the constitutionality of gun regulations in light of the Second Amendment. Thomas asserted that only regulations that do not infringe upon conduct explicitly protected by the Second Amendment and align with the historical traditions of the nations can be considered constitutional. This means that they must have parallels in the types of regulations that were in place at the time the Constitution was drafted. In dissent, Justice Stephen Breyer argued that this approach was deeply impractical and imposed a burdensome task on lower courts that may be difficult to accomplish. Prior to this ruling, lower courts were gravitating towards an approach that weighed the impact of a restriction on gun rights against the government's rationale for implementing the law.
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use, basic pistol.
Getting assault weapons, AR-15s, out of the hands of people who shouldn't have them.
The influx of litigation following the Bruin decision is revealing just how much this new standard will reshape the legal landscape surrounding firearms. For instance, A federal district judge recently cited the ruling to halt Delaware's restrictions on possessing and manufacturing untraceable firearms. The judge stated that defenders of the law failed to present compelling evidence of similar restrictions in historical records. Similarly, the Bruin precedent was invoked to put local assault weapon bans on hold in 2 Colorado jurisdictions. Notably, the judges in these cases were appointed by Democratic presidents. Just recently, a federal judge in Syracuse relied on Bruin to temporarily suspend several New York restrictions, including limits on carrying firearms to sensitive locations like summer camps, domestic violence shelters, and zoos. This ruling has even impacted long-standing laws that had previously withstood legal challenges. For example, Texas's public carry handgun ban for 18 to 20-year-olds, which had been upheld by the conservative 5th U.S. Circuit Court of Appeals in 2012, was struck down by a district court last month. The judge pointed out that there were no historical analogs from the founding era to support Texas's prohibition. Gun safety advocates argue that there are instances where the historical record supports their side. Additionally, there have been cases where restrictions on convicted felons possessing firearms were upheld due to a historical tradition of excluding those who have committed crimes from Second Amendment protections. In light of these developments, it is anticipated that the historical evidence surrounding firearm regulation will play a crucial role in future legal battles on this issue. Eric Tershwell, the executive director of Everytown Law, emphasizes that historical evidence will likely demonstrate a tradition of regulating firearms in various respects. Shifting legal landscape. The Bruin ruling, in introducing the historical prong of the test, has shifted the burden of proof onto the government defending a gun law. Now, they must demonstrate that the restriction aligns with past practices. This alteration has granted gun rights groups an advantageous position in court. It has also changed the nature of the work that government defenders, along with the gun safety groups that often support them in litigation, must undertake to advocate for their laws.
If you were serious, you would acknowledge that 96% of mass public shootings happen in an area where guns are banned.
That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
This transformation presents a challenge for legal professionals who may face tight deadlines to respond to lawsuits. Carlton Larson, a legal historian at UC Davis School of Law, highlights the difficulty in quickly formulating a thoughtful historical analysis in such scenarios. Gun rights advocates argue that this historical analysis is more fitting for courts than the previous means-ends balancing test. According to Peter Patterson, a lawyer at the firm Cooper & Kirk, which has represented gun rights groups in high-profile cases, the old approach required courts to act like legislators. In contrast, he asserts that historical analysis is a more inherently judicial task. Furthermore, the Bruin decision emphasizes the importance of the first prong of the legal test, determining whether the conduct being burdened is covered by the Second Amendment in the first place. This aspect has been somewhat overlooked in prior litigation over gun laws. As lower courts begin to apply the new precedent, various questions left unanswered by the Bruin ruling will be addressed and debated. While identifying laws in the historical record may be relatively straightforward, there remains room for judicial discretion in interpreting how closely a contemporary law must align with its historical counterpart to be upheld. In practical terms, Bruin implies that modern gun laws do not need to be identical twins of historic laws.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
They were assaulted and shot by someone and couldn't defend themselves because their guns were taken from them.
Reasoning by analogy is permissible. However, as demonstrated by U.S. District Judge Glenn Sotheby's recent decision on a New York gun law, the historical parallels do not uniformly apply to all aspects of contemporary legislation, requiring careful consideration in each case. Unanswered legal questions post-Bruin decision. As lower courts begin to apply the new precedent set by the Bruin ruling, several crucial legal questions have emerged. One such query involves the extent to which contemporary laws must align with their historical counterparts to pass constitutional muster. While the process of locating laws in the historical record may seem straightforward, David Koppel, an adjunct scholar at the libertarian Cato Institute, points out that there remains room for judicial discretion in this assessment. Regarding the Bruin decision's impact on previously deemed presumptively lawful gun laws, established in the landmark 2008 Heller case as constitutionally permissible, The Bruin ruling has raised questions about whether these exceptions may now be subject to re-evaluation. Furthermore, a significant point of contention centers on the historical reference point for evaluating the constitutionality of gun restrictions. Should it be based on the 1791 enshrinement of the Bill of Rights or the 1868 ratification of the 14th Amendment, which extended protections against federal infringements on gun rights to state and local governments? Gun advocates argue for considering the earlier time period as the relevant benchmark.
Well, Mr. Wilcox, there's no law. Congress didn't pass it. That's a rule from ATF.
It wasn't a fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
In the wake of the Bruin decision, legal experts find themselves navigating a somewhat ambiguous landscape, with the ruling leaving considerable discretion to judges in determining the appropriate level of generality in historical analysis. This aspect introduces a layer of subjectivity into the assessment of whether a contemporary gun law possesses a valid historical analog. Congress and Court. If we imagine a hypothetical situation where Congress tries to undercut or undermine the authority and independence of the Supreme Court, it would probably involve legislative acts or measures intended to change the court structure, scope of authority, or method of decision-making. Such measures might have a big impact on how the U.S. government is structured in terms of power. Attempting to alter the Supreme Court's makeup is one of the most direct ways Congress could try to have an impact on it. This might entail court packing, the practice of adding new justices to the court. The court's overall stance on legal and political issues could be changed by the appointment of additional justices who share the majority's political views. The Supreme Court's appellate jurisdiction may be regulated by Congress. They could enact legislation that restricts the kinds of cases the court can consider, thereby limiting its capacity to rule on certain divisive matters. This can be done to guide the court away from certain legal or policy issues. Congress has the power to impeach and dismiss federal judges, including justices of the Supreme Court, albeit this rarely happens. Congress may start impeachment proceedings if they think a justice is behaving improperly or in a way that conflicts with their judicial duties. The House of Representatives would need to approve the process with a majority vote, and the Senate would need to approve the removal with a 2/3 majority.
You are issued weapons that allow for fully automatic and 3-round bursts. That is not available for purchase.
How I am and my kids are going to be safer if I lock up my guns. I just feel, actually, as a female, I feel not as safe.
Through legislation, Congress could try to overturn particular Supreme Court rulings. As it effectively contests the court's reading of the Constitution, this procedure may be acrimonious. In extreme situations, Congress could propose constitutional modifications intended to change the makeup or authority of the Supreme Court. However, it's crucial to note that successful legislative overrides require a supermajority in both houses of Congress, which can be difficult to achieve. This would need to be approved by 3/4 of the states and a 2/3 majority in both chambers of Congress. Safety and rights in balance. The shifting opinions on the Second Amendment highlight how closely personal freedoms and societal safety interact. It acknowledges the significant societal costs of unrestricted access to firearms, a topic that is typically at the center of debates over gun regulation. This changing viewpoint shows an awareness of the inherent risks associated with a broad interpretation of the Second Amendment rather than an outright rejection of it. It underlines the necessity of preventing tyranny.
Why do we have guns? Why do we have the Second Amendment? Is it to hunt? Sure.
Gives private citizens the right to possess a firearm, including a pistol.
Self-defense? That's even more important.
A fundamental idea that significantly influenced the framers' conception of the Constitution. The most important thing in this discussion is to acknowledge the need for balancing interests. While there are legitimate worries about the social effects of readily available firearms, it's important to remember that the Founding Fathers carefully weighed these worries against the dangers of an unchecked government. Understanding the recent Supreme Court position on the Second Amendment, as outlined in Justice Thomas's opinion in the Bruin decision, depends critically on understanding this historical context. In essence, when the Second Amendment was ratified, the founders had already performed a detailed review of the public interest in connection to gun ownership. The foundation for assessing current regulations is this historical review. The onus is now on the government to show that such limits are supported by historical data dating back to 1791. The social effects of the Second Amendment. The multifaceted view of the Second Amendment and its wider societal consequences must be taken into account when examining potential congressional efforts to gain influence over the Supreme Court. A recurrent issue is the idea of a lofty cost connected to the widespread accessibility of firearms. There is an inferred allusion to worries regularly voiced in public discourse surrounding gun violence, even though specific data may not be explicitly stated. This emphasizes the need for a thorough analysis of these statistics because they could not always give a complete or accurate picture of the problem at hand. Furthermore, it is important to carefully address the complicated issue of who gains and who can lose out as a result of the widespread use of guns.
Quote, the right of the citizens to keep and bear arms has justly been considered as the palladium of the liberties of a republic.
The Second Amendment to the United States Constitution, Mr. President, as you well know,
contrasts us with the tyrannical governments of Europe who are, quote, afraid to trust the people with arms.
Since premature conclusions run the risk of oversimplifying the situation, this calls for an admirable degree of intellectual honesty. In conversations on touchy subjects like gun control, such caution is essential. The speculative situation of who would be most impacted by the introduction of firearms is also discussed. There is a suggestion that people who rely on physical dominance, or bullies, may have their authority challenged. This viewpoint emphasizes the idea that firearms can act as an equalizer, giving individuals who might otherwise be at a disadvantage in physical altercations a method of protection. Furthermore, a crucial issue relating to the Second Amendment's broader societal ramifications has been brought up. The argument is made that the right to keep and carry arms protects citizens from potential tyranny by the government. Guns offer a potential check on government overreach by providing citizens with the tools to defend themselves. This viewpoint is consistent with the Second Amendment's original purpose, which was to guarantee that people could fend off oppression. Assumedly, the strategy promoted encourages a careful analysis of the Second Amendment's varied ramifications. Avoiding oversimplified or biased arguments shows a willingness to engage with the complexity of the subject. Second Amendment nuances. At the individual and societal levels, the Second Amendment is crucial. At its essence, it acts as a defense against tyrannical governments, a principle that finds resonance in America's own history of revolution against repressive authority. This historical background highlights the amendment's stated goal, which is to serve as a deterrent against potential government overreach. The Second Amendment is not without its complications, though. As with any strong tool, concerns may arise due to the accessibility of firearms, especially in light of gun violence. Statistics are frequently used in political and media circles to promote various points of contention in the discourse around gun violence. However, it's important to examine these figures cautiously, understanding that they might not always give a complete or true picture.
Since it offers a strong moral check against the usurpation and arbitrary power of rulers.
That's not a right of government. That's a right that each of us has as Americans.
In order to do this, Democrats in this body are willing to take away a citizen's God-given right, yes, God-given right that was mocked earlier.
Additionally, the effects of guns go beyond personal defense. By giving individuals who might otherwise be at a disadvantage in physical altercations a means of defense, the availability of guns functions as a social equalizer. This dynamic alters the balance of power and provides defense against possible aggressors. In essence, firearms act as a materialization of the idea that everyone has the right to self-defense. The Second Amendment acts as a deterrent to international violence on a larger scale. The historical idea that a gun or a rifle behind every blade of grass would prevent foreign invasions exemplifies the symbolic importance of a well-armed populace. This idea strengthens America's dedication to self-determination and freedom by serving as a check against future foreign tyranny. However, intelligent honesty is required in discussions of the Second Amendment's nuances. It's important to be aware of the dangers that could result from easy access to weapons. This is an endorsement of the complicated interplay between rights, duties, and potential consequences, rather than a plea for the blanket support of arming every person or nation without appropriate analysis. In the end, the Second Amendment symbolizes a fine line between society obligations and individual liberty. It forces us to consider issues like self-defense, leadership, and the possibility for abuse. In order to create a society where rights and safety coexist, it is crucial to have intelligent debate and make educated policy decisions. A nuanced perspective understands both the empowerment and risks connected with firearms. Expanding gun rights. The Supreme Court's decision in New York State Rifle and Pistol Association v. Bruin marks a significant development in gun rights jurisprudence. The court found New York's concealed carry law unconstitutional, effectively expanding the right to own a firearm for self-defense outside of one's home.
We have a Second Amendment because we understand in this country that there are some things, inalienable rights.
The American people have considered the handgun to be the quintessential self-defense weapon
that you cannot justly take away from a free and equal human being.
A precedent initially established in the landmark Heller case. Justice Clarence Thomas, writing on behalf of the court's majority, expressed reservations about the subjective role played by New York state officials in determining whether an applicant for a concealed carry license meets the state's criteria. This concern highlights the potential for arbitrary decision-making in the licensing process. Crucially, the court differentiated New York's law from other gun safety regulations, such as the background checks outlined in the Bipartisan Safer Communities Act, which tend to have more clearly defined parameters. This decision raises an important question that now confronts other courts and legislatures. Where exactly is the line drawn between reasonable discretion and excessive subjectivity in matters of gun licensing and regulation? The ruling prompts a reevaluation of how states and localities approach the issuance of concealed carry permits, demanding a clearer delineation of criteria and standards to ensure fairness and consistency in the process. Gun regulation after Bruin. The Bruin case has brought about a significant shift in the way gun safety legislation is assessed, potentially putting similar laws in multiple states at risk. Previously, the prevailing test involved two key inquiries following the Heller decision. First, whether the regulated behavior fell under the protection of the Second Amendment. Second, if so, whether the state's rationale for implementing the law outweighed the constraints it imposed. This approach, often employed in constitutional challenges to state laws, was considered customary. However, Bruin contended that this test, by allowing significant leeway to state officials, overstepped the boundaries set by Heller.
Tyrants disarm the people they intend to oppress. Those are the facts.
Justice Scalia said it pretty well in D.C. versus Heller.
Enable the people to resist and triumph over them.
In the wake of Bruin, the constitutionality of gun laws will now hinge on whether the explicit language of the Second Amendment covers the activities being regulated. In cases where it does, the government must provide substantial evidence that its firearms regulation aligns with historical traditions, thus establishing permissible limits on gun use. This new standard, however, comes with a notable limitation. It seems to narrowly focus on the specific regulation itself, disregarding the evolution of the weapons under regulation. Over time, firearms have advanced from muskets to semi-automatic weapons, significantly impacting the context in which these regulations operate. This disjuncture between evolving firearms technology and the static nature of the regulations is a key point of contention in the application of this new standard. It raises questions about the adaptability of existing laws to address modern challenges posed by increasingly sophisticated weaponry. As courts grapple with interpreting and applying the Bruin decision, they will need to navigate this complex terrain, considering not only the historical context, but also the contemporary realities of gun use and ownership. Ultimately, the implications of Bruin reach beyond the specific case, reverberating through legal debates surrounding gun safety and the Second Amendment. Second Amendment legal philosophy. The Bruin decision marks a significant milestone in Second Amendment law, following landmark cases such as District of Columbia v. Heller and McDonald v. Chicago. These prior cases affirmed an individual's right to possess a handgun for self-defense within their home. While upholding certain gun regulations, Heller also acknowledged the permissibility of bans on firearms in designated sensitive places like educational institutions and places of worship. However, the Bruin ruling introduces a potential challenge to existing laws. Maryland, for example, swiftly suspended a similar law in response to the decision, illustrating the immediate impact of the court's stance. At the heart of the Bruin case was the century-old New York State handgun licensing law. This law necessitated individuals to demonstrate a valid cause before obtaining a license to carry a concealed weapon in public. The plaintiffs contended that this requirement violated the Second Amendment. On the other hand, New York defended the law by asserting that the right to bear arms for self-defense outside one's residence is not absolute. The outcome of Bruen carries far-reaching implications for the interpretation and application of Second Amendment rights beyond the home. It prompts a re-evaluation of long-standing firearm regulations, demanding a delicate balance between individual liberties and public safety concerns. This decision has the potential to shape the landscape of gun control legislation across various states.
This is why the Second Amendment matters. It's not trivial. It's not something you just brush aside.
Shocking. Absolutely shocking.
This is the foundation of liberty. It's who we are.
Influencing debates on concealed carry, licensing requirements, and the parameters of lawful firearm possession in public spaces. That's all for this video, folks. See you next time.